Great, thank you very much. So we're just about to start again. Thanks everybody, I hope you enjoyed your lunch. Thank you for coming back promptly. I'm going to just hand over now to Katie to give you feedback on the group discussion you had this morning.
Okay, thanks. This is going to be nice and fast. I would ask, though, that someone at the table takes responsibility for the flags. And I'll ask you at the end of each of the case studies to see if you can identify the country. So I did mention earlier that I should have probably looked up the country flags myself. So the first case study was Mrs. G, who had an issue with accessing adequate housing. The Constitution provides that everyone ought to have access to adequate housing, and in relation to the questions, for all of the case studies, there were responsibilities placed on legislature, executive and judiciary to different extents, and there was, in many respects, no correct answer, or there were multiple answers under each of the what kind of steps could be taken, because sometimes it's about justifying your approach, whether that be developing a law policy or ensuring an outcome. So I'm going to jump straight to the answers in question 3. So in the case where Mrs. G took her case to court, the court did assess the reasonableness of the state's policy and asked the state to revisit its approach because it was unreasonable. Any guesses for those that had case study 1, which country we were discussing? Excellent, yeah, South Africa, round of applause. So it's reasonableness review, and the duty is that you take reasonable steps, and when it comes to court you have to justify that those steps have been reasonable. Case study 2 was dealing with austerity and changes to social security. It was not explicit in the Constitution exactly what was expected, but there was a human dignity threshold that was set, which was inviolable, and there was also an expectation that the state was a social welfare state. Again, questions 1 and 2, there was different aspects that could be arguably placed on different branches of government and different expectations in terms of what role they would take. But the answer to question 3 was that the court assesses, or it did assess the method for calculating the minimum subsistence to ensure it was fit for purpose, and it directed the state to revisit the flawed approach. Also took steps to assess the level of its subsistence in a social welfare provision, and look at whether or not it was sufficient to meet Mr M's needs in this case, and the threshold that was set was human dignity, so there was an actual assessment of what that means. So it was a hybrid approach, and the country in question was... Yeah. Excellent. So Germany, and that approach was essentially a hybrid approach within the court, where not only did they review the policy itself, but also suggested that the substantive outcome needed to meet the threshold of human dignity. Case study 3 is a very long constitutional excerpt which has direct incorporation. It's looking at systemic problems with housing. The residents take their case to court, and in this case, after some back and forward between the court and the local authority, where there was deferential remedies in place first of all, and the local authority didn't take steps to fulfil them, the court eventually ordered the state to design a suitable housing plan. It then took steps to seize funds to ensure the delivery of the plan. It then ordered the state to procure a tender that enabled the housing plan to be delivered, and ensured that the access to adequate housing was affordable. So it was a very interventionist approach, resulting not just in process, policy, but also outcome. Any guesses which country for case study 3? Oh, we have some. Yeah, so both Argentina and Colombia have structural cases and would perhaps have taken this approach, but this case was Argentina. So the final one is case study 4. So in this case, we had potential legislative changes to social security, and it was felt that so before the legislation was passed, the Human Rights Committee looked at the legislation, and the lawyers in that particular case, or in this particular committee, advised that it was potentially unconstitutional to take steps to reduce the amount available under the Act. The constitutional excerpt is the really interesting one that says that there is everyone shall be guaranteed by an Act, so it very clearly places a responsibility on the legislator to fulfil the right to social security. In this case, what did the committee do? Well, it did issue a statement that the legislation was unconstitutional. It sought a solution to ensure compliance with the Constitution and with international human rights law. It heard evidence from Professor Martin Scheinen in that case, and Carlo Tuori. You can read the committee's decision. Well, it's in Finnish, but heard on good authority. And they did propose a new approach that was compliant and that ensured a means-based approach. Gave the answer away. So for case study 4, the guest country, so Finland. So that's just to give an overview of how countries grapple with this. And what was really interesting to hear going round the tables is many people were actually placing it and trying to understand it in the context of Scotland to give it life. And what you'll see from that is that, you know, it can be complex, and sometimes perhaps it could be made much clearer in what is expected in law, but the actual particular circumstances that give life to the situation are important, and that all arms of government can intervene to assess compliance. Okay, thank you.
Well, thank you, Katie, for helping us set all that up. Thank you to all of you for participating so well in it. It clearly had some resonance across the room. That was great. You should also know we are trending on Twitter in Edinburgh. If you carry on tweeting and retweeting and doing all that stuff, we might even end up trending in Scotland. So that's really good to know. So moving on to the rest of our day, I'm really happy now to introduce Colm O'Cinneide to talk to us about his experience of making determinations of social rights as a former member of the European Social Rights Committee. Colm is Professor of Constitutional and Human Rights Law at University College London, and prior to joining UCL, he worked as a legal advisor in the UK House of Lords. He's published extensively in the field of comparative constitutional, human rights and anti-discrimination law, and has also acted as a specialist legal advisor to the Joint Committee on Human Rights and the Women and Equalities Committee of the UK Parliament, and has advised a range of international organisations. And between 2006 and 2016, he was a member of the European Committee on Social Rights of the Council of Europe. So many thanks, Colm, for making the trip to Scotland today.
Thank you, Judith. I'm tempted to say something outrageous about the royal wedding to get the tweet count up, but I won't. Must resist. I want to talk today in my remarks about, I think, a very key question in this, which is what added value can socioeconomic rights bring to the table? Because if you're working in public administration, in the public sector, in making law, in governing and administrating Scotland at any level, you're dealing with a complex and competing set of different standards. It's a complex policy environment. It's a complex socioeconomic environment. And there are different audiences demanding different things. And there's a number of different agendas in play. And if you're at the coalface, if you're working on housing for Strathclyde Authority, if you're trying to develop the Scottish Government's welfare policies, you're juggling balls. And the question is, well, what does one other ball being thrown into my juggling, how does this help me on a day-to-day basis? And I think that's a good question. It was once put to me in London by a very senior person in Hackney. We have incredibly complex housing allocation needs in Hackney. Difficult, challenging needs, where we face all these competing demands for our time, for our resources. How does talking about socioeconomic rights help any of this? Or does it just give us an additional headache? And I think that's a good question, and I think it's a question that deserves an answer. I'm going to try, in the time available to me, to give some idea from my experience and things I've seen and looked at about how making socioeconomic rights enforceable in some way does provide added value to public decision-making, public delivery of services in a context such as Scotland. Very, very briefly, and this is going to be a sneak preview of my conclusion, I think what it does is that it ensures that socio-economic rights considerations are given the priority that they often don't get when it comes to crunch decision-making times. When decisions about housing, healthcare, welfare, and other decisions are being made, either at the local level or the regional level, the socio-economic considerations often lose out in favour of competing pressures, not just resource pressures, but pressures for example, internal decision-making consistency, pressures to comply with standard administrative law judicial review requirements, pressure to move forward consultation timetables, pressure to respond to political points X, Y, and Z. And the actual core socio-economic rights concerns often fall out of the picture no matter how well-meaning people are. Incorporating socio-economic rights has the potential to rebalance the system, to ensure that these considerations get the priority status they deserve in a complex policy environment. I'm going to justify all of that by just talking from my experience as a member of the Committee on Social Rights, having had a very interesting experience of effectively spending 10 years monitoring state compliance across Europe with the European Social Charter and seeing how different countries deal with issues of socio-economic rights. And it's an incredibly diverse picture all across Europe. And it's not very clear, for example, that there's a golden model and a debased model, that certain countries are doing things fabulously, other countries aren't doing things so well. But what is clear, and this I have to say was interesting as a member of the committee coming from Ireland and the UK with certain expectations about socio-economic rights being marginalised in legal and governance systems, assuming that was the norm. It was quite an education for me to realise that wasn't necessarily the norm. In many European countries, socio-economic rights are something similar. So in Germany, the term socio-economic rights isn't usually used. Instead, it's the concept of the social state, the social stat, linked to concepts of human dignity. That's the way the discourse tends to develop, not so much socio-economic rights per se, but it's effectively the same thing. That the use of these ideas is much more normalized at the constitutional level, at the legal level, at the legislative level, and at the policy-making level. It's much more normalized in many European countries than it is in either the UK or Ireland. To give you an example from we'll come back to this, the Hartz IV decision of the German Constitutional Court in 2010 that Katie already mentioned. This concerned the mechanism through which the Bundestag sets minimum social welfare payments. And what's interesting is that this isn't a treasury-derived process. Finance counts for a lot, but there's an entire mechanism involving expertise and financial considerations fed into the process to try and identify the minimum level of social payments to which people should be entitled as of right to participate to a certain basic level of equality in the common life of their society. And there's a mechanism by which the figures are set, which are then debated and discussed within various Bundestag committees. Now, the Hartz IV decision saw the German Constitutional Court turning up and saying, actually, how you've done this calculation in this particular instance is wrong. It didn't give adequate weight to human dignity in certain respects. Go and do the calculation again. And that's interesting, and I'll come back to that in a moment when we talk about the role of the courts. But I also thought it was interesting that the German parliamentary process had this entire mechanism for debating and fixing social welfare rates that involved expertise, but which also involved a transparent political process which doesn't exist to the same extent in this country. And it's interesting talking about it and talking to German experts about it, how this is seen as being normalized. Because, of course, if you are committed to being a social state, if you are committed to the idea of having a sort of transparent rule of law mechanism governing your social state, then of course you should have a transparent decision-making mechanism through which human dignity is factored into these very important decision-making processes. Okay? And it was the normalization of what I've described elsewhere as European social constitutionalism that struck me in comparison to the situation in this country and in Ireland and other common law countries. Okay? Not saying everything is perfect, by the way, far from it. But there is a sort of an awareness, a normalization of social principles, social rights within the framework of many continental European states that doesn't exist here. And that's, I think, interesting. But it was also clear to me that there isn't a single magic bullet, that there isn't an off-the-shelf model where you can go, oh, well, we'll take the Finnish model. Fabulous. We're a small, semi-Nordic country, especially those of you from Shetland and Orkney might resonate. And so, you know, we'll go for the Finns. We're almost Finns, sort of. That's not the way it works. There isn't a model, there isn't a single off-the-shelf model that will work. All across Europe, European social constitutionalism takes dramatically different forms, very different roles for parliaments, very different roles for the executive, very, very different roles for the courts. And context can be very, very, very important. It's also clear that developing sort of a social constitutionalist, social rights-focused model, we need to get rid of some of the traditional thinking that sometimes dominates perspectives here. Human rights are often seen as open and shut matters. Has the state done something lawful? Has it done something unlawful? Is free speech violated? Yes or no? Someone decides, end of the story. Okay? But socioeconomic rights, by their very nature, are more fluid things. You see this reflected in the text of SHRC, as Virginia pointed out earlier. It's talk about minimum core, progressive realization. It's not an open and shut process. In fact, I often think it's quite helpful to think of socioeconomic rights as being, in a way, closer to fundamental rule of law principles, structuring principles of state action, perhaps in some ways close to fundamental administrative law principles. That isn't to say that they aren't hugely important rights, okay? But I often think it's important to remember that when we talk about how they might take effect within a national legal system, that they won't necessarily take effect like Article 10 of the European Convention on Human Rights guaranteeing free speech. They might instead be a standard of review, a way of provoking government justification, a way of structuring discussions within Parliament, within the executive, within the courts, rather than a very simple set of open and shut legal tests. It's also crucially important to emphasize, and this cannot be said enough, that any role for the courts in this respect is going to be at the sidelines. Okay? And it can be a very important sidelines. Substitutes can be hugely important people when they come running on. But that the main heavy lifting in this area is always going to have to be done by the legislator and by the executive. Okay? And ideally, you would be constructing systems for protecting and promoting socioeconomic rights, where the heavy lifting would be done by parliamentarians, advised by civil servants, working with ministers and so on, and where the courts will play a supplementary reinforcing role in this regard. And you want to make sure that socioeconomic rights aren't just a toy for the lawyers, but that there's something that can be internalised in decision-making processes within parliamentary committees, within executive decision-making rooms, within the legal political process in general. Okay? So that's some general points. Let me move on to make some specific points. And here I am going to talk about the law a little bit. There's a quote in Malaire about, in Tartuffe, I think, about a play where a character is delighted when he is told that, without realizing it, he had been speaking prose his whole life. Okay? It's a famous quote. He's delighted to learn all his life he has been speaking prose. Decision-making bodies in the UK engage with socio-economic rights every day of the week. They do it when you design legislation relating to homelessness and housing standards and emergency accommodation of children. You do it when tribunals interpret social security disability living allowance requirements. You do it when public authorities consider the positive equality duty. You do it when you look at certain aspects of the SHRC. All of this is going on all the time. Okay? And indeed, there are certain aspects of law as it stands that do provide some quite important indirect protection for socioeconomic rights. So there's a Supreme Court decision from around 5-6 years ago, KM versus Cambridgeshire, in relation to the withdrawal of disability benefits, where the Supreme Court said, actually, if the withdrawal of a disability benefit is going to have a very substantive impact on an individual's autonomy and sense of dignity, then that decision needs to be subject to extra elevated level of decision-making. Okay? Now, that's interesting because that's getting close to a sort of socioeconomic rights decision-making. So, I would argue that when we're talking about introducing socioeconomic rights into Scottish law, Scottish governance more generally, we're not necessarily talking about something that's radically different. What I think is lacking from the current system is that a lot of the legal norms ultimately come back to procedure, consistency, compliance with judicial review standards. There's a case I often quote, a case from London, the MacDonald case, a former Scottish ballerina crippled by disability, living in a flat in Kensington and Chelsea. And basically her needs were assessed and she wasn't given the support she needed, 24-hour care effectively. And the local authority basically said, well, you can put up, I'm simplifying, but you can wear a nappy overnight. You don't need a 24-hour carer, okay? And it was interesting, the legal analysis of this, because the legal analysis at the end of the day, the court subjected this to quite a lot of scrutiny, but their focus was on the procedure. Are you being consistent? Are you following the statutory guidelines? Have you ticked all the boxes in your consultation exercises, your review exercises? Have you talked about the positive equality duty and so on, so on, so on? At the end of the day, the heart of the matter, whether Miss MacDonald's human dignity had been adequately upheld, that sort of vanished out of the picture. And indeed, Baroness Hale, dissenting, very much emphasised this in her dissenting judgment. And it's precisely that gap that introducing some sort of concept of enforceable socioeconomic rights can add into the picture. Because if you suddenly have to say, okay, we need to justify what has been done for this particular woman, whether it's compatible with standards of dignity. And we'll need to justify this by reference to Article 3 of the Scottish Bill of Socioeconomic Rights or whatever. And we may have to do it before the relevant parliamentary committee. We may have to do it in front of the minister, whose constituents have been shouting at him or her about it. And we may have to do it under a judicial review mechanism. And it's no longer going to be good enough for us to say we followed correct procedure. Instead, we are going to have to justify that an adequate threshold of dignity was crossed in that particular case. Okay? That's what making socioeconomic rights enforceable can I think, bring to the picture. Okay? Now, you may be going, especially those of you who work the coalface of designing policy in this is going to put insurmountable loads on the system. If you're handling housing in Strathclyde, Are you going to have to justify each failure to repair a local authority flat in the Greater Glasgow region on the basis of its violation of human dignity? Are you going to have a justification for all those repairs you haven't been able to get around to because of lack of resources and time and energy? No, the system isn't going to work like that. It can't work like that as much as we all like it to do. But by having some form of enforceable socioeconomic rights, you can, if you want, put pressure within the system to have a clear justification as to why key decision-making impacting upon the dignity of individuals or a distinct group, why the relevant decisions affecting their dignity were taken the way they were. Okay? And that's what's often missing from day-to-day decision-making, no matter how well-intentioned people are. It's the pressure, the need to show that justification for the substantive treatment of individual socioeconomic rights. That's what's often missing from the system. Okay? And I recognize if you do this, that it may put pressure on already burdened public authorities. But of course, what happens is that the pressure comes in anyway from different sources, and it can often help well-meaning public authorities focus more on socioeconomic rights, because there isn't a necessity for them, out of fear of parliamentary committees, out of fear of the minister, out of fear ultimately of the courts, there is a necessity for them to clear some time to engage with these substantive issues. When the positive equality duties were being introduced in the 2000s, there was lots of discussion. Public authorities are terribly hard-pressed, very complicated decision-making. The last thing they need is to have to be worried about race and gender and disability equality issues. I used to work in Parliament when this went through, and there was this entity, the small rural school in Cornwall. We heard a lot about the small rural school in Cornwall. Subtext, no black people. Okay? This was the unspoken subtext. And there were serious attempts made to say you could never have a positive equality duty because of the load, poor, hard-pressed school. Now, that was swept away because people recognised the need for the positive equality duty as a legal mechanism. Now, the problem with that mechanism is that, of course, it's procedural at the end of the day. Have you thought about it? That's fine. The advantage of a socioeconomic rights mechanism, however formulated, whether as a constitutional document or through legislation, or even incorporated through different legislative standards, is that I think you can achieve something with a focus on substance, where you compel public authorities to justify, is what you are doing compatible with basic norms of human dignity? And by introducing that pressure into the system, you may very well have better outcomes. I'm coming to the end of my time. Let me just give you an example of how this works, in case you think I'm just like waffling in general levels. German social security tribunals. Okay? Hands in pick a German city. Hands in Bremen. Sorry?
No, Bremen's good.
Bremen's good. Okay. Hands in Bremen is denied a discretionary social welfare benefit. Okay? He really needs it. Okay? He takes it to a tribunal. Interestingly, part of the German Social Security Tribunal's analysis is that they do ask the questions about human dignity. Part of their legal analysis is the human dignity threshold passed here? Now, interesting enough, that tends not to happen here. Because here, the human dignity analysis is supposed to be reflected in the background legislation, in the regulations. So here the question is, well, has the legislation been complied with? Have the regulations been complied with? And sometimes that leaves a bit of scope for discretionary decision-making, but often not very much. The focus is on the procedure. The substance of the matter disappears completely. That's not the case in the operation of the German Social Security Tribunals. Now, I'm not saying they're perfect, but in other words, there is pressure brought within the system because of this concept of European social constitutionalism, of the social state within the German context, that doesn't exist in this system. Now, the Germans don't have a full enforceable code of socioeconomic rights, but I just use as an example about the difference that giving some sort of formal, legal, substantive heft to socioeconomic rights can make in the context of hard-pressed public authorities making difficult decisions in difficult circumstances, as everyone have to do. Thank you very much.
Great. We've got a few minutes for questions. Virginia, would you like to come and join us again? So I thought it would be good to bring Virginia back onto the platform in case people have additional questions, or she would like to just contribute to the discussion. So the room is open for questions to Colm and Virginia. Yes, Carla. I now know your name, so that's good.
Me again. So just thinking about the German example and how CPAG could potentially use on it, draw on it. So you've said how the UK and Ireland are in a minority within EU countries. Yeah. So you've cited Germany in particular, but is Germany following a trend within other EU countries, and UK and Ireland are outside of that trend? And then within the cases that, for example, in the Constitutional Court case in Germany, was it purely litigated and argued with reference to the domestic standards, or was there any reference to ECHR or even UN human rights treaties?
It was purely litigated by reference to the German standards. Germany doesn't have enforceable socio-economic rights, which is a source of controversy. But the key thing is that their human dignity principle is interpreted by reference to the social dimension of the state. So it's not just human dignity in a, let's not be tortured sense. It's a human dignity in the sense of adequate support. In terms of a trend, it is quite striking that there is certainly as Katie said, globally, but in particular within the EU, there is more engagement with socioeconomic standards defined in different ways, not always called socioeconomic rights standards, but there is more active legal and political engagement with what we'll call generally social rights than used to be the case. And that's even reflected in the text of the EU Charter, for example, which of course actually contains social principles. That's an enforceable social principles. That's an indication about how things are moving on in the continental European context as a sweeping generalisation.
So I think, Colm, you were on the Joint Committee of Human Rights, but you said how parliamentarians will need to do the heavy lifting. So are bodies like JCHR, are the people who sit in them and those who work for them, are they dialoguing with other EU countries and trying to bring in some of this normalisation?
Not in the socio-economic field.
Any more? Yeah, over there, next to...
I was just wondering, what does the experience of the European Committee on Social Rights, particularly under the collective complaints mechanism, tell us about socio-economic rights adjudication generally?
I've left out that, which probably shouldn't have done, but it would almost be a whole talk in and of itself. It's been hugely interesting. The UK, of course, hasn't signed and ratified it. Portugal has, of course, as a leading socio-economic country. Portugal, by the way, is the best socio-economic right.
But to see if I let you.
Yes, that's true. But it's been really interesting because the collective complaints process allowed us as a committee to look into the detail of what states are doing, which the national reporting mechanisms don't let you. So national reporting mechanisms, your analysis is structured by the material that comes into you in the state. You're working off that piece of paper. Suddenly, collective complaints whereby NGOs and trade unions and employers' organisations can bring you a collective complaint. You suddenly get a much more three-dimensional picture of what's working. So, I'm sorry for taking time. Very, very briefly, a really fascinating case from France 10 years ago, Fianza versus France, prioritisation. French homelessness systems for allocating housing to persons who are homeless, wasn't really well regulated. Considerable discretion was left to the local mayor and the Hotel de Ville, along with a general policy of trying to avoid ghettoisation. Now, that meant that they had a policy of actively waiting for nice middle-class couples to want to come into social housing to avoid ghettoisation. Now, there are very good public policy reasons for that. But what tended to happen is that certain mayors were very often allowing that to become paralysis. And there were issues about racial mix-up of some of the people going into public housing. But crucially, there was no nationwide priority simply had not been set. We said as a committee, it's fine for you to have a non-ghettoisation policy, but you need to have some structured form of decision-making in allocating homelessness. And actually, the French acted on that, and they've now introduced a much more structured decision-making process, giving guidance as to who's in need, who's not in need, and that has partially helped them to come to grips with what was a very serious homelessness problem 10 years ago.
Yes, can I add something? Colm gave me I think he gave me the entry points in terms of Portugal and other countries who do have a strong economic, social, and cultural rights ethos, at least. I'm not saying that in practice the protection is guaranteed, but even then, Colm, if I give you the example of Portugal in terms of the fiscal adjustment program, in spite of the fact that we have a good constitutional background, we have strong constitutional universal provisions, the decisions were taken without any consultation. So when you say that having it incorporated, having it in the Constitution means that there is an added value to the recognition, it doesn't work in practice. Because when the decisions were taken to cut on social spending, there was very little attention paid to the fact that at least you required a participation process.
Well, what about the Constitutional Court decision?
But that was one good thing that came out of it. But it was just a non-discrimination issue. The Constitutional Court decision was because the public sector was being penalized, and it was a discriminatory issue. But in terms of the normative content of the rights, you had absolutely no decisions. And there was really, of course we had them, but when push came to shove, those were the first rights to go.
Yeah, we can have a separate discussion about this. Interestingly, what was interesting for me on the Committee on Social Rights was that the austerity crisis was quite striking, because the austerity crisis saw lots of normal decision-making swept away under the pressure to cut budgets. So this happened in Greece, it happened in Italy. I don't know enough about Portugal, whether it happened there. But what was interesting was that it was an exception, because this particularly happened in Italy. The normal structural decision-making processes designed to protect socioeconomic rights, under pressure, were swept away. So it's why a lot of the austerity literature in Europe talks about a state of exception, because the normal socioeconomic rules of European social constitutions, which can be quite weak, were swept away under the pressure of the austerity crisis. And this was seen as a crisis. Whereas, frankly, in the UK, austerity has been slightly business as usual. It hasn't involved any new decision-making process. It's been more rolled out with greater enthusiasm than usual, but it hasn't involved any particular new constitutional administrative processes, whereas in a lot of continental Europe, it did involve quite new decision-making processes. So I don't know if that partially answers your point, but certainly experience in Italy and several other countries was very much like that.
This is something we need to follow up on a bilateral basis, because it would seem that if it is an exceptional measure, then once you're out of austerity, then you regain your normal consultative powers.
Yeah.
But that is not happening.
Yeah, it is.
So I don't know if it's really that exceptional.
Okay, I suspect this will run and run. But thank you, Colm, particularly for that just really interesting contribution around the whole kind of how that works, how that applies in practice in different parts of Europe. That's really helpful. So I'm going to move on to the next conversation we're about to have.